Chrissy, over my 40 years of law practice, I've done thousands and thousands of wills and trust, and I tell people probably less than 10 times as one of my clients included their son-in-law or their daughter-in-law in their estate plan. So what are we saying? Pretty rare. On the other side of the coin, we get a lot of people that will say something like this: Tom, I want to make sure that my daughter-in-law doesn't end up with my money, or my son-in-law doesn't end up with my money. And then we got to break it down for the client. That is this, that if if you've included your son in your estate plan, more than likely your son is going to survive you. That means he's going to inherit his share of your wealth. It's going to be his to do with as he please. And the bottom line is that his wife is probably going to end up getting some benefit, or ultimately maybe all that money if their son passes away at a later date somewhere down the road.
Yes. And you're right. Those are the things it is really important about having that conversation. And that's where, one, we want to take your particular situation that you said earlier about each one is a little bit different. This is where each one, they can have a little bit different circumstances, but we're going to guide them and help them to the right way to meet their goals. And that's oftentimes where when people will say to us about, I think I'm going to try LegalZoom, or I'm going to do one of the online versions. This is where you're not going to typically get that guidance when you're doing something online to know that it is going to match the way that you want it to be. And you're right there. It's very common for people to have, at a minimum, questions, sometimes concerns, and sometimes they're adamant about not including the daughter-in-law or son-in-law or significant others.
When I tell the client that, hey, your son, more than likely, he's going to survive you, and once he inherits his share of your wealth, it's his to do with as he pleases. His wife, your daughter-in-law, is going to get the benefit of it, more than likely, one way or another. They usually get it. Okay? Mm-hmm. It's like, okay, Tom, really nothing I can do about it. It is what it is. Mm-hmm. Occasionally, somebody will say, Tom, that is just not satisfactory to me.
Right.
And we got to go to some kind of more radical remedy. And I throw out to people that I've done it before.
Well, and that's where it involves, you have to do a trust. So first of all, it's about, it will become more complicated.
Yeah, it does.
Because you have to do a trust.
So
and then you can
I've
customize the wording.
Literally done a trust before that says, okay, when we parents pass away, if my son is still married to that woman, then his share will stay in trust for the rest of his life, and he will only get it, and upon his death, it will go to our son's children, our grandchildren. But if by chance during his lifetime he divorces his wife, well, then he can have it all. Mm-hmm. So that's very, very radical. I don't recommend it, but there are some people that just feel that adamant about the whole situation that they're willing to put something in writing like that.
And that's where it goes to, yes, it's a bit more complicated, but also you're not going to be able to easily do that online.
Exactly. So we do that for people, and whatever we do, I've done a trust like that before for people many, many years ago, and then they'll come back and see me later on and say, Tom, things have changed. I'm okay with our daughter-in-law now. This is not what I want to do. We need to change our trust. And one way we could do it would be to amend the trust. And the problem with amending the trust is that everybody's got access to all the previous versions, and they're going to see this previous version where they talked about, daughter-in-law and how much, in a sense, they didn't like her.
Because the original doesn't go away.
Exactly. So there's a better remedy in that situation. It's called a restatement of trust. Mm-hmm. And in a restatement of trust, you throw out all the original trust and all the amendments to it. You keep the name and the date of the trust, but you start from scratch. It's called a restatement of trust. So usually we're using it because people have amended their trust so many times, 3 or 4 or 5 amendments to the trust. We finally say, look, let's just scratch all those and do a restatement of trust, make it nice and clean for people. Mm-hmm. And that's a restatement of trust is a very nice tool for cleaning things up.
It is. And again, you're right, because it is very common that when somebody does a trust for whatever their reasons, it is very common that things change.
Now, the other thing is that sometimes people will come to us with a 30, 40, 50-page trust, and we tell them, look, this is just way more complicated than it needs to be. And we might have two options. One is that we just abandon a trust. But if they say, Tom, I already have properties and bank accounts that are owned by that 30-page trust, we say, well, at least we can do a restatement of it and make it much more simple and easy for you to understand. And boy, are they grateful about that.
Absolutely.
And folks, we do offer a free initial consultation to talk about your estate planning here at the Olson Law Group. We can do that initial consultation in person, over the phone, via Zoom, whatever is most convenient to you. Here at the Olson Law Group, you can talk to any of the attorneys here, me, Attorney Chris Merrill, but we have a lot of great attorneys here that can assist you with your estate planning. Any of them would be great for you. Call the Olson Law Group next week to schedule your free initial consultation, talk about your estate plan at 407-423-5561, or go through our website and you can schedule that time. Hey folks, my name is Tom Olson. The name of the show is Olson on Law. You're listening to News Radio WFLA.